All right, let's go ahead and get the not guilty plea first, and then we'll talk about time. Great. All right, the not guilty plea has been entered, and Mr. Creasy requested, instead of the 10-day deadline, 30 days to file motions. Is that right? This was also an objection.
We have no objection to that.
All right, I'll give you 30 days to file any motions and extend the timeline for 10 days. We're going to handle what's on the daily calendar now. That is Mr. Creasy's motion on behalf of Mr. Faust. It is a motion for bond. Determination of bail status has already been waived by his defendant. Mr. Cruz, this is your motion. You may proceed. Of course. You may proceed.
You're also about a motion that's relevant to this hearing.
I'll ask you to speak into that microphone, Mr. Cruz, if you don't mind.
This
So we can hear you. Thank you.
also about a motion that's relevant to this hearing, Your Honor. One thing I would ask, Your Honor, is that I respectfully request bonds to be set on our pending criminal convictions for we're charged with one count of malice murder, 4 counts of felony murder, 1 count of burglary, first degree, 2 counts of aggravated sodomy, 1 count of rape, 1 count of aggravated assault, 1 count of arson, first degree, and 1 count of possession of firearm, a knife, during the commission of felony. Your Honor, especially since the defendant enters the proceeding cloaked with a presumption of innocence. You see what they don't do on the right side of the bench. The decision of the defense counsel in the relevance of this case is here to learn the extraneous issue of guilt or innocence until the bail proceeding did not conclude and goes on to a separate issue. But the purpose of this case, Your Honor, is as within your Honor, because guilt or innocence is relevant at the time of the state. So that's power from the state. The next case, Your Honor, I provided for is United States versus Solardo. This is a U.S. Supreme Court case. This is the second case in the case law provided to Your Honor. The site is 481 U.S. 739. And Your Honor, the language here is on page 8 of that case. Here I'm on the left side of the page, the last paragraph, division 3. And it states, in our society, liberty is the norm. And detention prior to trial or without trial is the carefully limited exception. We hold that the provisions, and this was speaking specifically about the old act that covers, similar to the statute that we have in Georgia. We hold that the provisions for pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The act authorizes the detention prior to trial of arrestees charged with serious felonies who are found after an adversary hearing to pose a threat to the safety of individuals or to the community. And this is the language I stress in the opinion, Your Honor, which no conditions of relief can dispel. The next case, Your Honor, is Jones v. Grimes. This site is 219, Georgia, 585. This is the 1964 case. Your Honor, I'm on page 2 of 3. On the third paragraph, in the left column, section B, note. It says, excessive bail is the equivalent of a refusal to plant bill. And this is going to be our issue here because with the bond that we're requesting.
Since forever, we've hated Mondays, but it doesn't have to be like this. Monday, introducing Monday Hair Care. On modern, award-winning formulas. Smooth, hydrating, and protect. No more bad Mondays.
This is not just online scheduling. This is vaccines made easy for those who've got plans.
Love playing games on your phone. What if you get? I've been using Playtime Perks. Then
We're asking that that bill falls within the 8th Amendment's requirement that the bill not be assessed. The next case I have that I'd like to report you on. This is a case, this is one of the most recent cases. This came out in November of 2021, which is 3 years old. This is Coleman v. State. This is 361, Georgia Appeal 901. And the language is on page 2 of 3. In this case, talks about excessive bill, which is obviously what we know at all. And then the court on the left side of the page, in the paragraph that is in it, excessive bill is prohibited by the Georgia Constitution and cites to that provision, and the 8th Amendment to the U.S. Constitution. For purposes of the 8th Amendment, excessive bill is defined as bill set at an amount higher than an amount reasonably calculated. And this is the language that I'm stressing on to assure the presence of the defendant. When the Dixon bill in Georgia, a Foremost consideration, and this is language stressed by the case. A trial judge's foremost consideration is the probability that the accused, in this case, Mr. Faust, if free to appear at trial, and this language is also stressed to a lesser extent. The accused will pay the seriousness of the offenses or offense, and the accused's character and reputation. A defendant who seeks release on bail has the burden of showing roots in the community, that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating police. Your Honor, you look at this same page, on the right side of the page, the first sentence, the last paragraph on the right side, and again, the court writes, certainly we are not unmindful of the limit, in this case, in Coleman's pre-trial detention, the language I'm emphasizing is and the presumption of innocence. The next case, Your Honor, that I provided to the court is a similar case in our state. It's a similar case in regards to bond hearings. It's Ayala v. State. That side is 262, Georgia, 704. Here on page 103 of this case, I believe the court is going to state. In our highest court rule, the purpose of pre-trial function is to prevent punishment for offense and to secure the appearance of the person in court for trial. And then it goes through the four-part test of how to deal with ties to the community, but showing ties to the community through not posing a risk of flee, commit a felony, pose a threat to individuals in the community, persons in the community, property in the community, or intimidate witnesses to interfere with this investigation. And next, Your Honor, we're on page 2-3, in the second paragraph, at the bottom, on the left side of the page. The court states, in this state, Georgia, unlike many other states, the presumption of innocence has always remained with the person accused of a capital offense, even during trial. The most, the absolute most fundamental premise of our criminal justice system is that a person ought not be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. Unless the right to bail or trial is preserved, the presumption of innocence is secured only after centuries of struggle will lose its meaning. The next case I provided another court in the state is Easy Out London v. State. That's 224, Georgia Appeal 706. This is the 1997 case. The court may notice at the top of this case there is a red flag. That red flag pertains to just briefly. Notice a subsequent case that came out related to a bail bonus obligation. If that bail bonus did not receive notice of the hearing for 72 hours. So that red flag is relevant to the purpose that we're quoting this case for. What we're quoting this case for, we didn't have this case, we got this case to do this, we are asking for all bond for this loss. On the right side of the page, in the middle paragraph 2 of 3, and it states, it is further assumed that a felon who is taking a financial risk, and in this case, Mr. Perry to be responsible for Mr. Faust's fund. It is further assumed that the appellant was taking a financial risk in assuring the defendant's presence at trial would be motivated to keep track of the defendant's case and to prevent the defendant's flight or relocation until the surety is relieved of its bond obligation. Such risk of flight is inherent in the criminal justice system, without which there would be no need to build bonds or bond sureties. And as I mentioned earlier, we have a mining company that is willing to take on Mr. Faust's fund where he is inclined to do Mr. Faust's fund. The last case that I just reported is Brown State. This is a 2012 case, Your Honor, decided 314, Georgia Appeal 1. This is a 2012 case. And the purpose language that I'm citing is on page 2. It's the right column, on the right side of the page, Your Honor, is the third paragraph top. And the appellate court wrote, the General Assembly, which is our General provided for the creation of programs of electronic pretrial release to, amongst other things, to assist jurors in alleviating jail overcrowding by creating alternative methods of pretrial release and monitoring, and this is stressing the case, and home confinement, which is language being stressed. Indeed, the General Assembly found that a program of electronic pretrial release, monitoring, and home confinement, which again emphasizes in the case, incorporates modern technology to accomplish various purposes. Thus, the General Assembly explicitly recognized a defendant's home as a place where he or she can be kept within the bounds restricted to movement for purposes of the electronic pretrial release program. And again, the reason I provide that case, that is what we'll be asking for in this case. And with that being said, Your Honor, that is the premise of the law, Mr. Faust, when the sheriff is on the privilege. I would like to call my next witness, my first witness.
Go ahead.
I would like to call Ms. Shaquita Thomas.
Yes, so you'll have to see the stand. Mr. Cruz, you may swear.
You put your right hand forward. You swear and affirm that the testimony that you're about to give before this court is the whole truth, nothing but the truth, so help you God.
Yes.
Your Honor, may the state not approach on the matter briefly?
You may. There has been an objection to video coverage of witnesses on the stand. The state has not objected to this resolution. And the media coverage, and that is a representative from, I believe, Court TV, who's here today, has agreed not to publish the faces of any witnesses on the witness stand during any recording that they make. Mr. Cruz has made a presentation as to why that is important for him and his witnesses, but based on the agreement by the state, and of course the agreement by Court TV to accommodate all parties, I'm going to grant that wish. And that will simply be for anyone on the witness stand. Mr. Cruz, you may proceed.
Just for purposes of the record, I'd just like to state that Ms. Shaquita Thomas, who was called, is none of us had notice regarding camera for Mr. Faust's case. She has declined to testify on behalf of Mr. Faust.
Do you have any other witnesses?
I do.
All right, go ahead.
Next witness, I attend the proper testimony of Ms. Sherry Everhart. However, if the court or the prosecutor asks questions from Ms. Everhart, she is present. Ms. Everhart, would you please stand up? Ms. Everhart is present. Mr. Everhart is one of Mr. Faust's.
You may be seated. Thank you. Go ahead.
Ms. Everhart is one of Mr. Faust's closest friends, Your Honor. She's 61 years old, and she has known Mr. Faust since 2005. She was born and raised in Georgia, and she currently resides here in Athens. Before she was disabled, she spent 34 years with Baker and Taylor, and I understand Baker and Taylor to be the largest supplier of academic library content in the United States, in our country. Before Mr. Faust's arrest, when I asked regarding how close were they, she said that he stopped by virtually every other day, parked his truck, stopped by for a quick chat, and they'll talk. Ms. Everhart testified that Mr. Faust was a successful car washing business here at Athens, Georgia. And she has never been arrested, Your Honor. Excuse me, she has never been arrested or convicted of a crime, and she is aware of Mr. Faust's history, which the state provided with. With this knowledge, Your Honor, in regards to the ideology background, Ms. Everhart will testify favorably on behalf of Mr. Faust. She would advise him before Mr. Faust would not flee if his Honor report was to grab Mr. Faust's bond. She would tell Your Honor that Mr. Faust has been arrested. He's been arrested previous times, multiple times. However, he's never fled. He's never fled court jurisdiction. He's dealt with all his criminals to conclusion. She would testify that Mr. Faust would not commit a felony. She would testify that Mr. Faust would not pose a danger or significant risk to the community or individuals in the community if ran as well. And she understands the basis for that when she explained to me. He said he's been out. He's been out. He hasn't he's had arrested. He's been out in the community. Mr. Faust did not intimidate any witnesses during his investigation of this case, rather bond. And Ms. Everhart will tell her that Mr. Faust, before he was in custody, he served the community. He provided jobs. She just like there's a crime problem with the youth, and Mr. Faust will take these individuals and keep them out of trouble, provide them jobs for this pressure watching to keep them away from street crime. Your Honor, Ms. Everhart isn't just saying this, she's actually willing to be responsible and sign Mr. Faust. That's how much faith she has in Mr. Faust. The next witness I have to testify is Ms. Linda Thornton.
When you're craving a delicious snack, there's good in every bite. Del Monte, growers of good.
Throughout our history, ordinary people
And Ms. Thornton will read that statement. Would please raise your right hand for this report. Do you swear to affirm the testimony that you're about to give for this report is the truth, the whole truth, so help you God?
Yes.
And can you please say your name for the court?
Linda Thornton.
Could you spell that for us, please?
Last name, okay. LINDA
Thank you so much.
Thornton.
Ms. Thornton, have you ever been arrested?
No,
Have you ever been convicted of a crime?
no,
Can you tell us on the court, are you currently employed?
yes,
And where are you employed? You don't have to say your job location, but what city is your employment?
state of Georgia,
How long have you been employed?
3.5 years.
What's your job title?
I'm assistant plant manager.
And do you know Mr. Edrick Faust?
Yes.
How do you know Mr. Faust?
Well, I first met him through his stepmom about maybe when he was 17, but I just knew him socially. But In the last 3.5 years, I've been knowing the person.
What is your relationship with this man?
I'm his fiance.
Can you tell them where Mr. Faust was born and raised?
Okay, he was born in Elton, but he was raised in North Carolina.
And where does Mr. Faust reside when he is not in custody?
In Washington, Georgia.
And how far is Washington, Georgia from that?
About 35 miles.
Can you tell us about Mr. Faust's profession?
He's had a pressure company that he wash cars, pressure wash, and he's been having a company like 7 years.
When you say he had a company,
He still has a company. I said have a company.
as the owner,
Yes.
does Mr. Faust have any involvement in the community that you could tell the report about?
Yes. He always tried to help the elder people. When he's washing like maybe 3-4 times a month, some of the elder people in the neighborhood that he grew up in, he washes their cars free. And also, if they need something moved, or he'll help them with lawn work or anything like that. Also, he does try to help the youth out if they're not working in his old neighborhood. He may hire them a couple days a week.
Is it fair to say you're getting nervous right now?
Yes.
You can do this.
Let my voice is because I have signs.
It's okay. Slow down a little bit for me. Court reporter, get everything you're saying. When I ask you a question, just talk.
Okay.
Just let the butterfly into that. You say 3.5 years, you stay out of town. Have we had any felony arrests or felonies that place in the last 3.5 years?
No.
Now, you mentioned you doing it 17, but you stayed within the last 3.5 years. Can you give us the significance of those?
Well, I knew him when I knew of him when he was 17 through his stepmom. I did not know him personally. I only got to know him personally the last 3.5 years.
Based on your knowledge of Mr. Faust, do you believe that he poses a significant gain to the community?
No.
Why not?
Like I said, in the last 3.5 years, as I know him, that he steers away from any conflict with people, and he likes to cooperate.
Do you believe Mr. Faust poses a threat to intimidate any witnesses or interfere with the police's investigation?
No.
Whereas one, no.
No.
How would you describe Mr. Faust's character as you know?
He's kind, considerate, loyal, dependable, courteous to others, and trustworthy.
Now, you've given a lot of testimony to this on before. I think the most important question that the court is always concerned about is with the credibility. If the criminal court was to grant Mr. Faust's vote, would you be willing to sign Mr. Faust?
Yes.
Do you want the property in this court?
Yes.
And how much is your property?
About 85,000.
If under the court was to say, Mr. Gordon, I heard everything you said that you're going to sign, she's going to grant, I want you to sign, and I want you to put your property. Are you willing to put your property on this cost?
Yes.
Now, Ms. Gordon, I have one more question for you. Under the court action, the bond order to state that Mr. Faust violates any condition of the bond, including the property. Okay? Knowing that you can lose your wealth, Mr. Faust violates any condition, are you still willing to sign the property of Mr. Faust?
Yes.
I have no more questions for you.
Ms. Gonzalez, any questions for Ms. Witness?
Yes, Your Honor. Good morning.
Good morning.
My name is Edrick Faust. I represent the state. In this case, I just have a few follow-up questions. You said that you are Mr. Faust's fiance. How long have you been together?
Well, we've been staying together for 2 years, but we was dating for 3 years.
For 3 years, okay, does that take it back to 2021, 2020?
Mhm.
You have to say yes or no.
I'm sorry. Yes, yes.
Okay. And, do you guys live together? You said something about staying together, but do you live together?
Yes,
And how long have you been living together?
about 2 years.
About 2 years, okay. Did you know that Mr. Faust was arrested in November of 2022 for simple battery?
No,
Okay, that would have been the time that you guys were together, correct?
yes.
Okay, so you're saying that you did not know that he had been arrested?
But I would object.
On what grounds?
I don't have this better policy. So I would say that it's alleged you can show me where he has a 2022 conviction for simple
Yeah.
battery.
I'm gonna overrule the objection. She's got this witness on cross. You can follow up with this witness when she's finished.
Did you know he was arrested in 2022?
Not a simple matter, no.
Were you with him as dating with him in 2022?
Yes.
So it means that you did not know everything that was happening with your fiance?
So we was probably staying the whole time of 2022 together.
Okay, so when,
I wasn't his fiancé, you know.
okay, so when were you his fiance then?
Well, we, probably last
Probably last.
Yes, ma'am.
So not
Sometime last
you.
year. Yeah, we was dating, yes.
Okay, and, you know, you spoke to the defense about how you have this property and it's worth $85,000.
Yes,
Is that most of your wealth
yes,
in that property?
yes,
And you're willing to sign it over for your fiance?
yes,
Are you willing to do anything for your fiance?
yes.
Thank you. No further questions, Your Honor.
Any rejections?
This is I have a question. If another court was to send Mr. Faust to 24 hours house arrest with GPS monitoring, would you be okay with that?
Yes.
Are there any guns in your home?
No,
Does Mr. Faust have a passport to your house?
no,
Are you confident that Mr. Faust will not provide alcohol?
yes,
Let me ask you a question. I'm not sure really take your time to think about this question. The state asked you, would you do anything for Mr. Faust? Your response was yes. Can you explain that to a little bit for us?
well, I was saying I would do anything to support him as far as the, and put my property and stuff up.
So it's limited to that you aren't saying, hey, I would do anything in the world, but you just said for the limited purpose. Yeah.
Yes, yes.
Thank you so much. I have another question.
Anything else, Ms. Gonzalez?
One last question. Ms. Burton, do you love him?
Stop playing games on your phone for free. I got paid to play games this week thanks to Money Time. You can actually earn money.
Rise and shine with a free adjustable base upgrade during the to-go Labor Day sale. Just
Thank you. No further questions, Your Honor.
Bruce, anything else, Ms. Witness second?
Yes,
You may second. Any other witnesses, Mr. Bruce?
I have no witness, no disclosure.
All right. Go ahead.
Your Honor, the way I understand the law, here, the imminent issue is blackness. That's the way I understand it, and that's why I gave it the code case. I believe that's the 2012 case. I'm sorry, that's the November 2021 case that I provided to the court. The agreement issue here is whether or not, if this open court gives Mr. Faust, whether or not Mr. Faust did. If the answer is that Mr. Faust would not do, if we could fashion conditions to assure us that Mr. Faust would not plead, he would appear in court, then we could address all the other factors, which are if released, would he commit a felony? If released, would he be a danger or threat to the community or individuals in the community? If released, would he intimidate witnesses or interfere with the police's investigation of his offenders? We're asking you today, Ms. Faust in custody, / home, we are today that the under court provides Mr. Faust to his home. And that's what we're providing in the Brown case, 2012 case. We We ask that he's confined to the home for 24 hours a day. We ask that he's only allowed to leave to visit me or medical, or we ask that he's allowed to work. The reason we ask that while Mr. Faust is in custody, although he has private counsel, over time, this case can take a year, this case can take 2 years, this can take 4 years. Mr. Faust becomes a fugitive, and it impairs our ability to defend against the charge. Our court realized that our legislature is using things such as GPS monitoring and house arrest rather than in-custody treatment that Mr. Faust is currently doing. What we propose for the Honorable Court in this case, and I gave Honorable Court cases discussing excessive money. One of the considerations is Mr. Faust's ability to pay. We ask that the Honorable Court set bond based on his presumption of innocence at $100,000 and require property as collateral. We ask for 24 hours house rules. We ask for GPS monitoring to provide the address to the court. I don't want to say the address, where this stuff will provide that address to the court. I have a company that's clear to big. Deal with Mr. Faust on this clear to big Mr. Faust in the bank loans. They provide the DA's office real-time tracking information. They provide updates every 2 weeks to whatever the DA's office provides those updates to, or report one of those updates. And the DA's office designated a person to call and say, hey, we want to see everything that Mr. Edrick Faust is whatever he's on, and they will submit those records. We ask that on the court, there are concerns imposed on the trust provision for these all check in, anyone on the information officer does it here, but we ask for the trust provision for this cost as well. We ask for no visitors outside of the immediate family, as testimony of Ms. Thornton, that she provided. Mr. Faust's parents, unfortunately, no one would. He has a daughter. We ask that his daughter be able to come visit. Ms. Thornton, she stays at home, I say she has no one to visit. I believe this would satisfy the reasons under our knowledge, satisfy the conditions and concerns of pretrial releases. Regarding both the name to felony or intimidating witnesses or interfering with the police's investigation. Based on this record, I would ask this on the board to permit me to answer any question that you may have.
All right, then this time, thank you, Mr. Chris. Any else?
Yes, Mr. President. I would like to thank Mr. Faust for the privilege and his honor to step aside and respect time of his life. I would like to thank your honor for the time you did today to present Mr. Faust's case. I would now like to thank the court for being judged for everyone at all times. In closing, Your Honor, I've already given the honorable court after the motion that we're rejecting as improper from the state. I'm sure the state is aware of this. We provide the state with a copy as well. To any dealings with state properties that Mr. Faust committed any, absolutely any of these indicted offenses, as we want to obtain the evidence, we want to challenge this evidence, and we do not accept the evidence. So we have a jury of our peers that's able to go and we're able. And we will know the case law that he is presumed innocent of any and all offenses at this time. Thank you very much.
All right, thank you, Mr. Chris. Ms. Gonzalez.
Yes, thank you, Your Honor. And I just just say the only witness we have here is a family member of the victim, and she would like to give a statement after the Commissioner.
All right, go ahead.
First of all, Your Honor, the state is accusing the defendant, Mr. Fox, of entering the home of Tara Louise, a young woman who was a first-year law student at UGA in her off-campus apartment that was located at 160 Dawn Drive in Athens, Georgia, on January 19th of 2001. The state is accusing Mr. Fox of violently attacking Ms. Baker, of sodomizing her, of strangulating her, of stabbing her in the neck, and of blunt force trauma to the head, causing her death, and then setting fire to her apartment to conceal the body as well as to conceal any extra evidence that there might have been of his wrongdoing. Your Honor, I will refer to the Ayala case that the defense did off, because that is what we are here to discuss, the 4 factors of the Ayala case and whether Mr. Faust is eligible for bond under those factors. Factor number 1 is the severity of the crime. Again, the defense has laid out what those crimes are. 4 felony murder charges, 1 malice murder charge. We have aggravated assault. We have arson. We have rape. We have aggravated sodomy. These are all serious charges, Your Honor, and are at the very top level of severity of crimes that the state of Georgia has recognized. This is a heinous crime. It includes the strangulation, stabbing, and the blunt force trauma to the victim's head. The second Ayala factor is a flight risk. Your Honor, throughout his history, we have him in different locations, in different places, and even his fiancée was not sure about how long they had been living together, whether it was 2 years or 1 year. Number 3, the threat to the public. Your Honor, this defendant has a 49-cycle criminal history. He has violent offenses, and he has over 20 probation violations, which means that he has shown a pattern of disregard to the most basic conditions of being out of probation, and that is, do not commit another crime. He has offenses such as aggravated assault in 2001, 15 days after Miss Baker's assault. And in there, he was charged and convicted with slicing a victim's neck. He has a battery in 2011, terroristic threats in 2018, violation of the family protected order, and you saw the simple battery in 2020. For these reasons, Your Honor, we do find it a threat to the public. Which brings us to the last Ayala factor, the likelihood to reoffend and commit these future crimes. And there you see, 49 cycles in his criminal history. He was out on bond, Your Honor, when the murder of Tyler Baker occurred. And so it is with the interest of justice and safety, Your Honor, for the community that the state does ask that Your Honor find the defendant a danger to the community and that you deny his bond. Thank you.
Thank you, Ms. Gonzalez. Before I get from your witnesses, can you please give me a recitation, Mr. Faust?
Yes, Your Honor, the criminal history begins in 1994, an underage possession of alcohol, 96, criminal trespass, 97, fleeing and eluding possession of firearm by convicted felon, carrying a concealed weapon, 1997, simple battery, criminal trespass, 97, robbery, 97, false names with law enforcement officer, 2000, death by shoplifting felony, 2001, parole violation conviction, 2001, aggravated assault, 2004, fleeing and eluding law enforcement officer, 2004, probation violation conviction. Number 2, 2005, driving while license suspended, 2006, probation violation conviction again, 2007, public indecency and indecent exposure, 2007, driving while license suspended, 2011, DUI, alcohol and battery, 2012, another driving while license suspended, 3 of them in that year. 2012, we have 3 probation violation convictions, followed by 1 in 2013. 2013, willful obstruction of law enforcement officer in possession of cocaine. Another 2013, possession of cocaine with intent to distribute conviction. 2014, probation violation, 2 convictions there. 2014, driving while license suspended, revoked 4th or more. That's a felony. 2015, 3 probation violation convictions. 2016, willful obstruction of law enforcement officer. 2016, we had 3 more probation violation convictions. 2016, DUI, alcohol, hit and run, driving while license suspended. 2018, another probation violation conviction. 2018 also is when we have terroristic threats and a second probation violation conviction. 2019, driving while license suspended. 2019, probation violation conviction, 2 of those, Your Honor. 2019, willful obstruction of law enforcement officer. 2019, harassing phone calls, violation of family violence order. 2019, 3 more probation violation convictions. 2020, 2 more probation violations. 2021, 2 more probation violation convictions, which brings us to 2022, our criminal trespass and simple battery. There is a pending charge in all of Clark County, Your Honor, from 22, a DUI alcohol, and then our charges here in 2024.
Thank you. All right. Anything else, Ms. Daly, any witnesses you want to hear from?
Yes, I would like to call Meredith Baker, Your Honor.
All right. Can you swear?
Can you please raise your right hand? Do you solemnly swear or affirm that the testimony you give this court is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you so much. May you please state and spell your name for the record?
Yes, ma'am. I'm very sorry. It's Meredith, M-E-R-E-D-I-T-H, Baker, B-A-K-E-R, Schroeder, S-C-H-R-O-E-D-E-R.
Thank you. And who are you in relation to Tara Baker?
I'm her sister.
Thank you. And you had a statement that you wanted the court to hear.
Yes, ma'am. That's right.
May you please proceed?
As we already stated, I'm Meredith Baker Schroeder, and I'm Tara's sister, and I'd like to thank Your Honor for the opportunity to speak on behalf of my family. January 19th, 2001 was by no stretch of the imagination the darkest day of our lives. As we made the 90-mile journey to Athens that night, we had no idea what lay in wait for us. Believing that Tara's death was an accident, it wasn't until we were sat down by the police that we were told that foul play was involved. That night, our lives were shattered, our childhoods abruptly ended, and although we have learned to breathe, walk, and live, gaping wounds in our skulls, we are not the same people that woke that January morning. We have strived to keep going and to live the life that was denied Tara. While she was only 23, she had already set the bar so high that it is yet to be reached. Now today, we face a defendant who is allegedly responsible for the heinous crimes committed against our Tara. We're cutting her precious, promising life short. We waited 23 years for an arrest and an indictment, and within those 12 counts, we learned just how horrific and harrowing Tara's last moments were. Since the arrest, I've done my due diligence, and I've learned how this defendant has lived these past 23 years without any regard for the law that Tara was hoping to one day represent. This defendant has been no stranger.
What's your objection?
Crime Victim Bill Act allows her to discuss how this has impacted her. She cannot make comments about response.
I'm going to overrule your objection. You may continue.
This defendant has been no stranger to this very courthouse or the surrounding counties for that matter. For 30 years, he has wreaked havoc on this community. He put a knife in a man's neck just a few months following Tara's death. He gave a false name to police. He was arrested for criminal trespass.
Objection, Your Honor, is the same objection. She cannot attack Mr. Faust under the Crime Victims Bill Act. She can discuss how it affects her. She cannot attack him.
I'm going to overrule your objection and make a comment that anything the witnesses say is not to be considered as evidence at this moment. You may continue.
Thank you, Your Honor. He was arrested for criminal trespass, battery, assault, fleeing police, distributing narcotics, harassment, stalking, and a lost count of all his parole violations. This defendant cannot go to Waffle House without throwing a tantrum, nor the 40 block without breaking a man's jaw, nor cruise without being arrested for domestic violence. At least we forget that he is far from UGA for indecent exposure. Your Honor, the defendant stood before you in 2019 for violation of the TPO granted by Judge Stevens for aggravated stalking and harassing phone calls of his ex-wife. In that bond hearing, you noted that this court finds that the defendant possesses a significant risk of committing future felonies and has a significant risk of intimidating witnesses. Given the reason that we are here today, I don't see how that previous statement can be less true.
Any further questions of this witness, Ms. Gonzalez?
No further questions, Your Honor.
Mr. Cruz?
Just,
Go ahead.
First and foremost, I want to say that I'm really sorry for you. I just have a couple of questions for you. The statement that you provided to us before regarding impact that this has had. Yes, sir. That would apply to anybody that would sit, that would be sitting in this seat. Is that correct?
That's correct.
And at this time, you don't know whether or not Mr. Wallace is actually the person who doesn't have anything. Is that correct?
That's correct.
Thank you.
Anything else in this witness's results?
No, Your Honor.
You may step in. Any further witnesses' results?
No, Your Honor.
Any further argument?
No further argument.
Mr. Cruz, this is your motion, you're the last one.
The Ayala case provides that it is the defendant's initial burden to put forth evidence related to all the Ayala factors. Once the defendant does so, the state, by abundance of the evidence, must show that the defendant is not entitled to bond, because the defendant is either a flight risk or the defendant is a danger to the community. At the bench review, I filed a motion objecting to the state's proper evidence. The state has presented no evidence on the issues related to this claim. Mr. Faust has presented evidence that is tied to the community. He's had witnesses testify that he is not a plea, and he's had witnesses testify that he's not a threat to the community, threat to the felony, threat to persons in the community, or pose a risk to intimidate witnesses or interfere with police investigation. I asked Judge that grant Mr. Faust's claim. He's presented evidence on his behalf. The state has presented no claim. We have case law, provides case law, and attorney property is not evidence that opposing counsel objects and requires the state to put up evidence via witnesses, evidence that just wasn't done. So, Mr. Faust is entitled to bond. I would ask that you grant the bond as requested. Thank you so much for your time.
Thank you, Mr. Cruz. All right, with regard to the issue of bond, both counsel are correct that the court must consider 4 factors in determining whether an accused is to be granted bond. The 4 factors are these: whether a defendant poses a significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. The state has not presented evidence with regard to that factor. Number two, whether the defendant poses a significant threat or danger to any person, to the community, or to any property in the community. The state by proffer has indicated some of the evidence that they have. And based on that evidence, it is clear to this court that the way in which the state has alleged these crimes happened show this court that this defendant, at this time, poses a significant threat to persons in the community. The third factor is whether the defendant poses a significant risk of committing any felony pending trial. The state has presented evidence with regard to the felony record of Mr. Faust. The felony record that the state has presented includes in the years 1997, several convictions from 2000, several convictions from 2001, 2013, 2015, and 2018. The court finds that that evidence is sufficient to show this court that this defendant poses a significant risk of committing any felony pending trial. And the last factor that the court must consider is whether this defendant poses a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state has not presented evidence with regard to that factor. But based on the evidence that the state has presented with regard to the proffer with regard to count 2 and the evidence with regard to count 3, I'm going to deny bond. Mr. Faust, you need to stay in touch with Mr. Cruz.